Welcome back to Law Call. You have Ted Howell with Perry & Young and Chad Templeton here to answer your questions on estates, wills, and trusts. Phone lines are still open, and I believe while we were on break, we got a call from Arnold in Washington County. Arnold, go ahead with your question, please.
Well, thank you for taking my call.
Yes, sir.
My wife and I recently moved to Florida from another state. In the other state, we had a will done. The question I have is, since moving to Florida, should we have another one done since our property is now in Florida?
Very good question, Chad. Arnold, that is something that we see quite frequently with the influx of people that we've had in Florida. What's your general advice on that? Even though that will may be legally valid, what's your thoughts, Chad?
Well, I mean, the first response is, we have a fair faith and credit clause of the Constitution, so if it was validly created in one state, it's valid in Florida. Now, my first question is, does anything need to be updated on your will? Do the people you originally had in power, do we need to update those individuals because they're no longer, you're no longer in that state? Mm-hmm. Florida actually has some unique rules that states if the individual is not a relative, they must be a Florida resident, So, but one thing I do want to impress upon you, Arnold, is we don't want our will to control our real property or our money. Because if we do, it will go through probate.
And explain some of the options you have there, Chad, especially on like the homestead and any other property you have in Florida.
So Florida has one of the best estate planning tools for real property that I know of, and it's called a ladybird deed. So if you have adult beneficiaries and you want to pass that property on to those loved ones upon your passing, then you create this deed. It's kind of like a bank account beneficiary, right? You own the property. When you pass, it automatically goes to these individuals, just like with a bank account.
Right.
So you can change your mind. You can cut them out if you want. You could sell it. They can't stop you. It's fully fully customizable.
But it's important to do that correctly, like you say, a ladybird deed, because a traditional life estate deed is something that you cannot revoke, and it's been done, and then you're stuck with that. So
that's right.
That's one of those situations. Chad, I mean, I would imagine your practice more than any has the potential challenge of folks going online, Googling, getting a document that may be effective or may be appropriate in another state, but Florida is very, very, very unique.
That's right.
If you have one, do you have any horror stories on that where somebody has done something similar to that and it's come out to not be such a good ending?
Unfortunately, I've got too many to talk about, Ted, but I mean,
give us one.
I mean, the most common one is, we have an individual who prints off a deed offline. They think they are just not even setting up a ladybird deed. They believe they're quit claiming it to their children, and they didn't have it witnessed. So these documents have strict execution requirements under Florida law, and so that individual tried to save a couple $100 by not seeing a lawyer. They ended up spending about $5,000 to probate that property. So sometimes it does pay to be, well, not sometimes, it just pays to be proactive, seek counsel, seek advice from somebody who actually does this for a living, because you could be saving your children or your loved ones a lot of time and a lot of money.
Right, because anytime you're doing something that is going to either affect real estate or affect a passing after your death, there are going to be formalities that have to be followed, and they have to be strictly followed. And so, for example, when we were talking to, I believe it was Rick from Mariana a little earlier, there's a lot of times situations where you can have contests on wills because either it was a forgery or they didn't follow will formalities such as signing by two witnesses in their presence and having it self-proving and notarized. So there are scenarios like that where even though there is a will, it can be contested. Another thing that we see quite frequently in your world is something called undue influence. For our audience, could you just kind of give a brief overview of what that is and the pitfalls of getting into those scenarios?
Well, I mean, undue influence is simply exerting your will upon somebody who may be susceptible. Maybe an elderly individual, maybe who has some diminished capacity. So, I mean, the most common scenario is you have a parent who has maybe two kids. One kid who wants to come into the parent's life or come back into the parent's life later in life and starts trying to convince them, well, we should do this with your estate and we should do this with your money. Takes them to the lawyer and has that.
Who is their lawyer.
Who is also their lawyer. You know, it's an undue influence analysis looks at a lot of factors. I mean, even to the point is who takes that person to the attorney's office and has it prepared? Were they in the room? All these things are taken into consideration. So yeah, I mean, a will contest is nothing to, you know, it's not an easy.
And they're nasty because
Yes,
it involves
yes.
family members. It's one of the worst things you can go through. So, you know, while Rick's parent in that particular situation has the God-given right to do whatever they want to with their assets, I would just encourage anybody to be upfront, tell their siblings, their kids, their spouse what they plan on doing with their estate, just broadly speaking, so that no one's surprised and everybody knows where things are going, so that it doesn't end up, hopefully doesn't end up in one of those will contests.